set up, but it's been set to the difficulty of a senior counsel. It would not be ethical for me to oppose that. 9.2 may be kept for day after tomorrow. Item 9 and 9.1 can be adjourned for 2 weeks. I have no objection. Lordship is keeping 9.2 for day after? Much of it. Thursday? Okay. I'm great to know. Fresh matter, it will come on Friday. Your Lordship. Lordship, in one matter. Only one matter. His matter is a fresh matter. Yes, and the other one on 21st. Great. Lordship, then can it be 23rd for sir? In those matters, can it followed? But
Lord, I have one provision to read, is section 12A, which has a power. First, I can take you to the recognition order, which is at page 130.
130
of the Nandan Singh's paper book. Nandan Singh SLP.
State SLP.
State SLP, sorry. Look, 131 is the relevant. Para 2 on, I will just read. And whereas in view, well, are there, at page 131, the recognition order by NCTE for this NODL sportsman. 131 is a relevant para sec 2. It starts at and whereas in view of the above mentioned direction of the Ministry of Human Resource Development under Section 29 of the NCTE Act and after considering after considering recommendations of expert committee, after considering all recommendation of expert committee, chairperson of NCTE exercise of his power under clause 12 of the NCTE recognition norm and procedure regulation 2014 granted relaxation by NCTE headquarters letter dated so and so to the following provisions in the NCTE regulation 2014 for ensuring that the directives of the MHRD for implementing the amendment to the RTE Act 2019 are duly fulfilled. In that, my lords, the second one is important. Any provision related to the duration of the program.
So this has to be read with reference to the directions of the MHRD.
Yes.
And the directions of MHRD are for a specific purpose. So as to provide a window to the persons who are already in employment and that they don't get out of employment by 31st of March 2019.
Yes.
So it will have to be read in that context. It can't be read in isolation.
Now down, my lords, what has happened since we reduced that pause to 18 months and provided it online and duly recognized, many states offered that, many people appeared for that. And that's where the problem started and everybody approached the different high courts. So Patna High Court and Tripura High Court allowed them to do so. And those orders were not challenged. That's been the stand of NCTE.
On the contrary, NCTE should have challenged those orders.
They had not, unfortunately.
Yeah, it's unfortunate. How could a relaxation for a specific purpose be used to give them equal status?
No, because they were in service experience.
So in service for the limited purpose of protecting their service.
Absolutely. I'm not arguing on that.
So the MHR direction, the HRD direction is only with that regard.
I bow down that. That's the only limited submission I have. I do not want to waste court's time.
Thank you.
I'll just take 5 minutes just for your lordships to consider the...
You are appearing for?
I am appearing for the impeded parties. We were in the writ petition ourselves, but we were not made parties here.
Impeded parties means D.El.Ed.
We are,
or 18 months or 18 months.
To be clear, we had 18 months, people in private service, and we are arguing that we should be allowed to apply.
Mm-hmm.
Your lordships have repeatedly said, and I think we can't go beyond that, your lordships have said that the power, I implied at least in what your lordships are saying, that the power to relax is there. And the power to relax on the basis of what the government of India has said, that power has been exercised. But as your lordship said, for a limited purpose. These were people in service they should not be knocked out of service because there was a limited time within which your lordships have rightly said. That your jobs should be secure. You should not be thrown out of a job overnight. Well, it's the limited purpose may well be achieved, but it's achieved because your lordships are recognizing the right to relax, etc., or the duty to relax. Well, what happens with us is we don't lose our job, but it's only once that this exception was being made. It was not for all times to come. So it was only being made now for us. We will retain our jobs, but we will not have the right to apply to get into a better job, i.e. a government job. Well, for that, I'm only seeking your lordships to consider whether a purposive interpretation of that document can be done as to what is the indication for power to relax. Is it to put you on power, which some reading might suggest that you're on par with the 2-year course, or it is only specifically, as your lordships have said, to protect you in your jobs. And my lords, considering the fact, as your lordships have observed, that the orders of the 2 high courts were not challenged, and they were proceeded with in the manner in which we are trying to argue we should have been proceeded with, and the High Court in Uttarakhand has in fact proceeded with it. My lords, that would create 2 classes of people, one who have this on par with the 2-year course, and one who will if your lordships go against us, would not be on par with the 2-year course. So, my lords, I'm only seeking that your lordships look at it purposively to see that this was not a permanent solution. It was just a solution for a specific time and place where there was no way that we could have been told to go and do a 2-year course because the time was not available. Retrospective application.
Specific purpose.
What is the purpose? Your purpose, your lordship.
Specific measure for specific purpose.
Well, if your lordships come to that conclusion, then really I can't argue any further that this was limited to the purpose that your job should not be taken away from you. But if it was for the purpose, and I'm asking your lordships or urging your lordships to consider it purposively, that this would amount to implied equivalent to who have a 2-year qualification. If you want to apply, you will be able to apply, etc. Otherwise, we'll have a job for the rest of our lives, but we will never be able to apply. Even in future, we will not be able to apply because we would artificially be put in a little bubble where we have a job, but we have no prospects of going further. Everybody else who are with us, who have been with us, have been teaching with us, have the same experience. If they have the 2-year course, they will go. And that will done. I don't know whether the government will think of another notification where the course by distant education will be made into a 2-year course or not, but it
is already over. That was only for that particular period.
So it was okay. I'm grateful, my lord. It was over. It's now over. There is no proposition now. And being over, it means I will never be able to apply for a job because my equivalence
and that course will not introduced for you. You will be thrown out of the job.
Well,
and only to protect you in the job, that special window was opened.
Right. Thank you, Manoj. And we are grateful to the government for having done that. So our job, even people who were in the government service, who were government teachers, who didn't have the qualification, would have got the qualification and remain where they were. They will continue as government teachers. But I will not have any further prospects because as far as I'm concerned, your lordship will treat it as one-time solution to leave me in the job, rather than put me on par with anybody else who would apply, selected or get rejected on this purpose. So I will be denied the opportunity of a job. That is the critical matter if your lordship interpreted in one way, and if your lordship interpreted it purposively, then I would be able to apply for the government jobs in future.
How would be purposeful interpretation of the principle of purposeful interpretation applicable?
Well, I'm grateful. All I'm saying is that at that time, when the government gave
on the contrary, if you apply the principle of purposeful interpretation, the interpretation will be against you. The purpose was that the persons are in job, they are without qualification, in view of the RT Act and particularly Section 23 thereof, if they don't acquire the requisite qualification within a particular time, they will be out of job. And with that purpose in mind, the government came out with a special scheme, the object of which was to protect you in your employment.
Well, that's your lordship reading on that document is that this was the limited purpose. But the several documents that Mr. Arora read to you, lordships, they all deal with it in terms of
several documents only lead to that conclusion, and it basically emanates from the direction of HRD.
Well, it emanates from the direction of HRD. Direction of the HRD is saying that this is the immediate concern. But in all fairness, my lords, the HRD didn't say that this is our limited concern, that you take care of their job now, no future prospects. This is only for a limited purpose. But as your lordships read, it obviously reads like this is what they were wanting to address. But were they wanting to address it in a manner, I ask myself, that cut off all opportunities for future for me?
That is what document says. The protection in present day would not mean opportunity in future.
Well, I understand. But
there are two different things.
But your lordship will consider that people placed in my position, whether they are in Odisha or they are in Bihar, would be able to apply. They would have already applied, possibly got jobs, and they will apply in future as well. If I have a future opportunity, I still will not be able to apply unless, of course, I resign from my job or take leave and go and go and do the course for 2 years. I will not have the opportunity.
They have got the opportunity because of a wrong judgment of a high court. We cannot be made to follow that.
Would your lordship take it against me?
You cannot rely upon a wrong judgment, which according to us, not subject to whatever we decide.
Well, if your lordships come to that conclusion, obviously there is no opportunity. But all I'm saying is that this has no dominant effect. This will not be something that concerns people who will come after us. It will be only for a limited persons, only once that this is done, which was the intention of NSTCE, but they have unfortunately at that time not thought of that not only should we give them an opportunity to stay in the job, but also provide an equivalence. So what I'm saying is, would your lordships be able to consider, if possible, consider that there's an implied equivalence, if not a specific, explicit equivalence of one course with the other. That, of course, my lords, is an exercise normally which is done where an authority sits down, compares the qualifications, and then comes to a conclusion that this is an equivalent. But in the manner in which this thing has been processed and has proceeded, I would urge your lordships to consider whether there could be implied equivalence for the 18-month online course.
In the absence of minimum qualification regulation for recruitment as teachers, if there would have been no such regulation, probably we may. There is a regulation in place.
For which purpose?
How can we provide for a read implied equivalent which is contrary to the regulation?
Well, but for which purpose? I'm only asking your lordships to look at the Regulation 12. Regulation 12, which gives the power. Regulation 12 that gives the power to exempt.
And we have not heard of any such principle like this implied equivalence.
Well, you haven't, but I'm urging because this seems like a very unique case. Something like this should have.
The unique principle you want us to.
Well, good. Your lordships lay down. Your lordships are developing principles all the time.
Every day. Law is evolving.
Law is evolving.
Or organic.
It's only when your lordships see that there is merit. Your lordship will consider.
We don't want to devolve.
Something like evolve. Because I'm only seeking evolution. I'm not seeking devolution. Well, your lordships develop outstanding jurisprudence when your lordships brought in curative petitions, right? Nobody had heard of, and in fact, world over, nobody has heard of something of that nature, beyond review, beyond reconsideration, etc. But your lordships did, because there may well have been a case that was promising, that was persuasive, and your lordships thought to do justice, let us find a way out, and your lordships have. Similarly, I'm seeking in this case, my lords, to do justice to a case of people who are not in any way not in any way responsible for what has happened. Your Lordships are saying the judgment of the High Court, which may be wrong, cannot sustain this. But what chance did I have? I was given an opportunity to go and do an 18-month course. I did the 18-month course. I applied in due course. There was, in fact, an order, the government order of the government, which clearly said that I had a right to apply. They then, of course, on reflection, changed their mind.
We may or may not accept you, but you are in the right track.
Well, I'm grateful that
Argument-wise,
I'm grateful that at least up to this point,
legally probably,
at least very difficult up to this point that I've been able to come, and then, well, it's ultimately your Lordship will look at the fact that this is only one group of people. Their whole life career depends on this. What your Lordships will finally decide, even if your Lordships were to show displeasure in the manner in which.
Only one question.
Well,
You are asking about what will happen to their life. If the NCT would not have come with this window and provided that 18 months course to you, what would have happened to their life on 31st of March 2019?
Because we would have been out, but your Lordship knows so many teachers going out is not a good thing either for the state or for the country.
So they have been protected and they should continue where they are.
And therefore, I only urge your Lordships to consider whether this protection should come with offering something to me and then taking back an opportunity for lifetime, for future. Therefore, I will be stuck where I am. That's all I'm seeking your Lordships to consider when your Lordships take a final view. I'm deeply grateful, my Lords.
Only I'll take 2 minutes, Lord. Oh, the idea of getting this training was to bring all these incumbents within the fold of the rules in question. And the fact of the matter is that once they have been brought within the fold of the rules in question, my Lord, they stand on the same footing. As of today, my Lord, in regard to the institution in question, it is true that it was a specific purpose scheme under which I have got the training in question. But fact of the matter is, my Lord, under the rules in question, as of now, I am to be treated as a duly eligible candidate in question. That is why, my Lord, your Lordship will kindly see that the central government, the Ministry of Home, at page 241 proceeded to write a letter to the council in question, Lord, asking them to consider the claim. And pursuant to this, the directive in question was issued, my Lord. That letter is at page 241 and page 242, which clearly proceeds with, therefore, in this backdrop, it is required to issue a clarification.
41 of which matter?
It is the same states matter, my Lord. It is at page 241 and page 242. It's a letter, my Lord, request for TET D.El.Ed by Nios cleared candidates of Uttarakhand. It is by Ministry of Education, Government of India, my Lord. Department of School Education and Literacy. Request for TET D.El.Ed by Nios cleared candidates of Uttarakhand state to allow them to apply for new vacancies of assistant teachers declared by the state in line of the state of Bihar. So this was a letter written by the central government, my Lord, exercise of its power under section 29. I am directed to refer to a letter dated 16 November 2000 received from Uttarakhand Nios Teachers Association on the subject mentioned above. It has been requested that the teachers of Uttarakhand who have completed D.El.Ed course from Nios may be made eligible to apply for new vacancies declared by the state in line of the state of Bihar. It would be pertinent to mention here that High Court of Bihar in so and so has cleared teachers working in government-rated private and schools to allow for appointment as elementary teachers training degree will be considered as a recognized degree for the same. Further, the department and city accepted decision on Honorable High Court and decided not to file any appeal against this. Therefore, in this backdrop, it is required to issue a clarification to all states and UTs. Those candidates who have completed D.El.Ed course of Nios may be given opportunity to apply for fresh recruitment at par with other D.El.Ed candidates, subject to adherence to all other criteria and qualification requirements such as passing TET, etc. So the central government has proceeded to write this letter, pursuant to which everything in question has been accepted, and even the state of Uttarakhand proceeded to accept the same. And subsequently, they have tried to rescind the same. This letter is very important, my Lord, because it's a letter of the central government.
yes.
And your Lordship will also see, my Lord, that to take a call on the question of equivalence, it is the competent authority is the NCT. The NCT has taken a call that it is equivalent. Once the NCT, that is the competent authority under the Act in question, has taken a call, that your Lordship will kindly find, my Lord, where the NCT has been conferred with authority to take a call on the issue of, that is at page 104, clause 5, interpretation. If any question arises relating to interpretation of these regulations or equivalence of various teachers training program, the council shall So once there is a directive of the central government, my lord, pursuant thereto, the council has taken a call. Pursuant thereto, my lord, the High Court has proceeded to pass an order that our claim in question, our candidature in question should also be considered. I submit, my lord, that once we are falling within the scope and ambit of the rules in question, because whatever rules are applicable, the institution in question wherein currently I am assigning my duties, my lord, they are covered by the same set of rules. In case I am not permitted to undertake any future exam, it will be blocking my road, my lord. So in that perspective, I respectfully pray, my lord. There is no infirmity in the order that has been passed. That is all, my lord. God bless you.
No, but whether NCT issued any communication after this?
Yes, they have issued a communication.
Where is this? Where is that?
I'll just
Page 250 members of the same essay.
page 250.
पहला वाला पीस है
250, my lord. Dated 6 January 2021. It is addressed to the Chief Secretary, all state UT government as per list. The subject is validity of D.El.Ed program conducted by Nios for training of untrained in service elementary teachers regulation. And the letter in question of the ministry is referred, and then this directive is in question is issued. And that is why the state of Uttarakhand proceeded to accept it, but subsequently, in their wisdom, they chosen to recall it.
Then why the regulation was not amended?
I am very thankful to my friend for point.
1 minute, Mr. Let him complete.
It was a decision of the government. The central government's directive is to be complied with by the council as per section 29. And that is what the council did, my lord.
See, when the field is occupied by framing a regulation, a statutory regulation,
That is
there cannot be any direction
Oh, that-
on the administrative side.
what it's not on administrative side, not the
It is
central.
administrative side.
The central government has taken a policy decision, my
It
lord.
would have, central government should have amended the regulation.
It is the same central government that has taken a
Who
call. my
stopped
lord.
the central government?
At the first instance, my lord, certainly we were going out, so training was important. This is the second now model when fresh opportunity of getting employment, my lord, that has been blocked. That is
Yes, you were saying.
Just a minute, Lordship may have the letter. My friend, I am very
May I
thankful,
seek
Mr.
your-
Shukla.
Yes, yes.
This letter of
Mr. Arora wanted to add something. You were saying.
6.
You are also appearing.
Yes. As per for similarly situated applicants, we were the original writ petitioners before the High Court. Now, by way of 3rd May order, your lordships allowed my statement, because I am not going to trouble your lordships with the constitutional scheme. Knows that under list 3, education falls, and there is a central legislation which occupies the field. In terms of section 23, your lordships have seen all that. I will not repeat anything. I just wish to propound on 2 points. If in 2018 or 2019, I would have known that instead of this 1.5-year course, I had to do the 2-year course, I would have possibly left my job, done that and applied. I can only look up to one authority, and that is the NCTE. I looked up to them, they said you are entitled to do it, I did it, I participated in it. That your lordships will keep in mind. Second, today there are 3 buckets of people that are before your lordships.
No, but NCT did it only with the direction of the, in pursuance to the direction of
HRD.
MHRD,
That's
only
right.
in order to protect your services,
That's right.
not for any other purpose.
But I would respectfully submit, that though this is the purpose that your lordships are interpreting it to be, but according to us, it entitles us to also, though that's an argument, it also entitles us to participate. There is no exception in that document for that. If I am entitled to hold on to a post, Malaj, there is no law which can prohibit me to apply for it. Today, your lordships are sitting in a jurisdiction where my lords will decide fate of three classes of people, Malaj. First are those, and this case certainly arises out of a fascination for government job. Please appreciate that. Today, there are certain set of teachers who are already in a government job, they are holding a post. They were also equally protected by this order. There are certain people, Malaj, who will apply afresh. Certainly, they have to have that 2-year D.El.Ed course. No difficulty there as well. Third is our category, Malaj. We fall in the private school. Now, if the interpretation that your lordships are proposing to accept is accepted, Malaj, tomorrow, even for the existing government assistant teachers, there will be no opportunity without leaving their job, doing a 2-year course, then applying again. So what essentially is
if a government teacher who has got benefit of that scheme and has been
kept in service,
and if there is any post for headmaster subsequently which requires particular qualification, then he will be debarred from that.
That's right.
The only purpose was to protect them so that they don't come on road.
I'm only placing Malaj for your lordship. Of course, Malaj, we are at a position where we can only request your lordship to also consider our fate. Where Malaj, of course, they would not sort of demote themselves from coming from government to private. But we are the only exceptional cases which are left out, who were told that, who were at least shown Malaj this hope of doing a 1.5-year course and then possibly be eligible to apply.
The only hope was shown was that if you do this course, your services will not be terminated.
Well, we took it, Malaj, and rightly or wrongly, Malaj, it was nobody who stopped us from it. We took it to be at par. Greatly.
Thank you.
Let me respond to his submission that he would have resigned and gone for the course. He was perfectly aware that this is a course, this is a program to enable him to continue. It was relaxation. This order was issued way back in 2017. Thereafter, in 2019 and 20, the advertisements were made for the selection to the post. They continued to submit, they did not put a challenge to the selection proceedings. As of today, they say, they woke up in 2021 when this NCT came out with this circular. They did not challenge this. Look here, I'm also qualified at par with this B.Ed and D.El.Ed here. They kept silent, they never put up challenge to the advertisement, which continues to survive. Now I'm very thankful to my friend Mr. Shukla. Lordship, I'm 178 on my, this pointing out this order to the court.
Your paper book.
My paper book.
Why don't you refer from this paper book and it?
What is it? This is Jaibir. Mr. Shukla read out the direction by the NCT to chief secretaries. I'm very thankful.
Yes.
They have no case. After this, they have
241.
241
And 250.
41.
Their state's appeal.
He read 241 and 250.
And on the 6th of January.
That is 250.
250. Now, he is relying on this. Mr. Shukla emphasized this is a letter by the NCT. They should have issued a notification and all that. So now the first page is referring to some direction received from the central government. Now, Lordship may come to the 179, the last paragraph. Keeping in view of the above, it has been clarified that the NCT has already decided to accept the verdict of the Lordship, I'm sorry. This is going on. Patna High Court in the case of Sanjay Kumar and others. Therefore, this is very important. You are requested to consider all those candidates who have completed D.El.Ed course of NIS and may be given opportunity to apply for fresh recruitment. Here the recruitment pertains to 2020. So it will become prospective in the worst case. It will not be applicable to the advertisement, the recruitment which is already in process. It's for the fresh recruitment. Now, Lordship may have.
Why are you arguing that point?
ये तो बुद्धि खराब है ना ये वो करो
They are
यार
lying on it. It's for the fresh recruitment, not for the recruitment which is already under.
Yes, means if they are qualified for fresh recruitment, why not make them qualified for
No,
the
because
pending ongoing?
in that case, 70% has already been appointed. The Lordship may
You are arguing against you.
Lordship may page 37 of the June judgment. Just 2 lines and I'll complete it. Requires Lordship, because initially Justice Gawai at the outset and thereafter Justice Misra also said about it. This regulation 23(1) is very important. Page 37, top. Regulation 23(1).
Page 36.
Just the same. Any person possessing such minimum qualifications as laid down the academic authority authorized by central government by notification shall be eligible for the appointment as a teacher. Now the NCT Council tried to place the lines on the government direction under 20A in the communication of 2017. 2017, where they said that the central government has empowered them. Now look here, as again, I'm sorry, Roger, I'm repeating myself, page 164. It is clarifying 2017's communication. Roger, ma'am.
Page 164 of?
My paper book. Javis. इनका कौन सा? 6th of September. अब पे नहीं है. मेरा, this is my paper book is this is very important.
It's not in Mr.
No, it is not.
Lordship may have it.
Why don't you people provide?
In any case, Lordship is a co-passenger. I am the one who prepared that when the state came later and then joined the issue. Lordship, my one page 164. So the entire submission of the NCT is taken care of. They rely on a communication of 2017 whereby they said 12A is coming to their rescue and they could have done it. The center, they were empowered.
What is your answer to the argument by the other council that if I am qualified to hold my position as a teacher today, why
That's
not be treated as qualified for all?
I'll also come to that.
That was the argument.
I'll also come to that. But it has to meet the legal requirement.
As a teacher,
That is subject.
teacher,
Yes.
as on date, on
What's
this qualification,
But the state,
why not he is qualified?
but the state does not consider it because our service regulations don't permit this. For us, Lord, 2 years plus 6 months training. That is the basic which we require for our purposes for the
So
state.
that was the challenge.
That is as per the.
But precisely that was the challenge. You may not recognize.
No,
But that is the challenge here.
no, there is a basis why we say this. Our service regulations are based on the NCT regulations which were notified. Till today,
Yes.
NCT has no regulations framed. They have not issued any notification under Section 2J of the RTA. Unless they issue a notification, then the state will consider. Today, we consider only 2 years plus 6 months as the basic, which we require for our state. So whether a person is qualified or not will depend upon not as the induction policy for our state. We only want 2 years plus 6 months. If they do not, they are only entitled to remain in service.
For releasing grant in aid,
Yes.
you will treat these teachers who are working in the aided school
Yes.
as a validly appointed and fully eligible teachers, yes or no?
Yes.
Yes. Quite.
Then
Only
if
for purpose.
they are eligible teachers
Relaxation.
for purposes of grant in
It
aid,
is only for them to retain the post, not no further promotion.
Yes.
No further promotion. They will not be entitled
The
to the.
Lordship, this is the last submission. Lordship, I have 164. That means the NCT's submission to the court. They are relying on a 2017 communication which empowers them to do it. Now, Lordship, I have 164. The 17 stands clarified.
1 minute.
$164.
Yes, that's my paper book, JBC. Lordship is having this.
Yes.
Yes. Justice Gai probably is. Lordship.
His paper.
Lordship may come straight away to subclause 2. As per the NRC NCT order dated 22nd of September, the one which was read out to the court by the NCT Council. 17. The D.El.Ed ODL program, they are not calling it as any other concept, but program, FNIS is only for those untrained teachers.
This is already read in the
No,
morning.
no, no. What are they saying? Because they cannot bank on 17. It's clarifying 17, what NCT was banking on. Underscore pointed by such and such, the duration is 18 months. Hence, next one is very important. For the plus appointment of teachers of primary and upper primary level, the notice dated such and such, 10 and 11. need to be strictly adhered to TET also primary 2012. This was never put a challenge to. Advertisements were never challenged before the court. They waited for 3 years. Advertisements were put way back in 2020. 70% success has taken place. They had no grievance. It's only they come in picture post this NCT's circular, which is not notified. And 23(1) requires that to be notified. And the High Court, in its wisdom, says it is not required to be notified, while making a reference to the section 23(1), and it still says it's not required to notify.
So this was in 2019.
Yes,
But thereafter in 2021, they say that allow all of them.
then there is no notification.
This is also not a notification.
This is
Also a community clarification.
no. It is saying that what has been notified, the regulations stand notified. They will only be added. The regulations will be added.
And every decision is taken by, we don't know who is taking these decisions. His undersecretary is writing all the time letters. Such important policy decisions.
It's a communication.
Undersecretary is writing letters all the time.
It's a not
If we drawing the letter.
government department. It's always the undersecretary or joint secretary who always say, "I am directed to." I am directed.
I am directed.
It's a communication.
At which level decision is taken?
Rules of business and law.
Top level, at which level? He is not saying I am directed to say by the.
But that is why we also have the difficulty. When a letter
You
comes,
also issue therefore one letter in January, another letter in February, and third letter
we
in
write to us, central government has said
Creating a map.
all right. Then we realize it is contrary to our rules, so therefore we withdraw it.
Thanks, lots.
My lord, we can't give up. See, the Nios, the partner. My lord,
The letters are by additional secretary. Anita Karan is an additional secretary at page 170.
Yes, we have seen.
She is an additional secretary. She's a
GOI letter.
yes, ma'am. The Government of India letter. She's an additional secretary. She's not a.
Thanks,
my lord, my
You
195.
should have argued before they began. Where are you?
I was actually
Waiting for?
seniors to conclude.
Just following.
Mr. Sodhi was also
Seniors of this side or seniors of both the sides?
Both the sides.
Both the sides. It is not the.
Hello, sir. I'm sorry I was not here. I had a matter which was specifically fixed at 2 o'clock for a settlement. So therefore, I had thought my learned colleagues will take some time. I just wanted to show one page and I'm leaving it there if my lords will allow. Only if my lords feel it.
Yes.
My lords, I have the certificate that is issued to me, which is at page 235 of that paper book. It categorically records D.El.Ed. It's page number 235. It's of the same paper book.
Yes, Javir paper book.
One of Nandan Singh Johara.
First half you.
Additional.
First half you refer to the other paper book.
My lords, can I just pass it? It's an additional document in the first matter. My lords may not open it, but it is there at 225. My lords can make a note of the page. My lords only look at this. It's additional documents. My lords may look at this. Please don't trouble yourself, because I only want to show that when I get a certificate, this is the kind of certificate that I get, and it clearly records it's a diploma. Now, once it's a diploma, then I am qualified like anybody else. It's not a relaxed, or it doesn't say that I am a person who has got it because of any relaxation. Diploma, my lords, is a diploma. And the qualification becomes equivalent.
What happens to their service rules and regulations?
My lords, I would say, let me answer that. The regulations, it has been shown by my learned colleague. I have shown the code page number 160, and this was amended again in 2019, which is at page 174. But my answer to this query that my lords put to me is this. My lords, we were in service. It is this particular qualification that enables us to continue in service. Now, I say this, that if as per your regulations, I am fit enough to continue in service.
If they, as per their regulation, they say that they want a minimum 2-year diploma.
Yes. Then, my lord, they should have removed me from service. then they should have removed me from service at that time.
Then that concession will arguing, we'll do it tomorrow.
My lord,
What are you arguing?
my lords, I am putting it.
Are you arguing?
Pick and
Arguing with
my
serious?
lords, they can't pick and choose. Is what I am trying.
Are you arguing this with real seriousness?
No, my lords, I'm putting it as a thing that if they claim that my diploma is not a diploma that the state accepts,
No.
then my lords, I qualified in 2015.
Thank you.
I have continued till 20.
Thank you, madam. Thank you.
I have continued till 2023.
Thank you very much. If you want, we will hold that.
My
The
lords,
state would be at liberty. If everybody agrees,
I am not.
we'll hold that the
My
state would
lords,
be at.
let me say, I put myself that question that you continue a person on the basis of.
That is because of the policy of the central government. Because of the intervening circumstances on account of
Because I can't put it beyond a point that once the central government recognized the qualification as a
for
diploma,
the purpose of continuing into services.
my lords, that's not stated anywhere.
If you read that HRD direction, it is stated at more than one places.
My lords, it's
That only in order to protect your services and in order to ensure that you are not thrown away on the streets.
my lords, I will end it by saying that
If you
I
want to-
make submission.
if
My lords, no, I just make a
No,
submission.
if Mr. Khurshid, Mr. Sodhi and if Mr. Shukla agree that we will hold that the government cannot discriminate and the government will discriminate them being disqualified.
I only want to put this that HRD letter which has been issued records also the aspect, apart from my laws, what they say, it says that these people have to qualify. It says that they have to get a qualification.
Qualifications so as to continue in their jobs.
Exactly. So I'm grateful. If I have to get a qualification to continue in the job and I acquired that qualification, then my laws subsequently after acquiring that
Madam,
qualification,
continuation in the
I may not be treated differently from
continuation in the same post and applying in response to the advertisement are two different things.
So my laws, only one last submission and I'm putting it there. Because the MHRD letter and the NCTE treats the teachers without qualification in the government, in the aided and in the private school at the same level. So people who were in the government schools without the qualification could continue. I only make a submission for your consideration this wise, that once I have acquired that qualification and I will be in private school, I would be then entitled to consideration also by a government school, because it applies equally to all teachers who did not have a qualification, irrespective of the fact whether they were in the government school, in the aided school or in the private school. Once they acquired the qualification, then my lords, today the teachers who were in the government school continue. But it is being said that we who are in the private school now cannot seek adjustment or consideration to participate in that examination. So my lords, we are not getting in automatically. We will also go in a competition along with all others. Only thing is our zone of consideration and our eligibility. The only thing is zone of consideration and eligibility at this stage.
Yes.
And my lords, if we qualify that and we have this, then I only respectfully submit that please do not treat us differently from our colleagues who by virtue of the same qualification are continuing in the government school. By a fortuitous circumstance, at that point in time, we were in the private school. Having got that qualification, we want to improve our future by participating in a competitive exam. My lords, that is my respectful submission, and that's only on that principle of Article 14. Please treat us equally as all others. That's it.
My lord, may I submit on behalf of the region?
And what is the finding of the Patna High Court? There is absolutely nothing.
My lords, Patna High Court holds that the 18 months, that was a sort of thing that was urged also in Patna High Court. They said it's approved. Can I show that observation of Patna High Court? Here's my note. I'll just give my lords the page of Patna High Court judgment. Would my lords come to page
Only reasoning given is 222.
222, my lords, towards the page 222. After going through the entire this thing, the material that we have also placed before my lords, paragraph number 14, from where perusal, it is apparent that NCTE recognized one time the course in D.El.Ed conducted by Nios. The relaxation of here was only granted in service teachers who had not obtained required degree training, such as B.Ed, D.El.Ed, which made a minimum requisite qualification for appointment on post of teachers in elementary and primary schools. Thus, it cannot be said that teachers who had obtained D.El.Ed through Nios and any other institute duly recognized by NCTE is not at par with the 2-year period D.El.Ed course as prescribed under section 23(2). This is the finding, my lords, of Patna High Court, and then Patna High Court goes on to hold further. If we may go a little further, it appears that NCTE has simply informed Additional Chief Secretary Education by way of clarification that as per NRC order of 22/9/17, D.El.Ed ODL program of NIOS is only for untrained in-service teachers in government-aided, private unaided schools appointed on or before 10/8/2017. But it is nowhere mentioned that the said course cannot be treated at par with the 2 years training course and on the basis of such direction 2-year degree course, whereas the same course was duly recognized by NCTE in pursuance of the direction issued by Government of India under MHRD under section 29 of NCT Act. My lords, now that my lords have seen this, please see Tripura for a minute. My lords will find
Tripura, we have seen Tripura also relies on this.
my lords, at 241, 237 and 241. 237 and 241. Apparently, I don't have that here. So, my lords, page 237, paragraph 15, my lords have that. From the above material, my lords have that. The body authorized to prescribe, that's NCTE, minimum standards of education qualification for trained teachers, and one authorized to prescribe the minimum norms for imparting education in such program has recognized the ODL program offered by NIOS for D.El.Ed course. This was subject to certain specific conditions, including that the duration of that program would be 18 months instead of 2 years, including 6 months of internship. The background leading to such recognition order would indicate that such limited relaxation was granted in the duration of the course, particularly bearing in mind the decision of Government of India, Ministry of Human...
Thank you.
My lords, then just page number, if my lords would like to see, page 241.
We have seen that. We have already seen that.
My lords, very well. I leave that there, my lords. My lords, I would only respect that we believe that we have that qualification, and I would request my lords to consider that once we are qualified, all of us, and we continue in service, we are recognized for continuing in service.
Then what happens to the advertisement, the rules regulation, which prescribe that the minimum course has to be of 2 years?
My lords, that my lords,
is the employer not entitled to prescribe a better qualification?
So my lords,
than even the prescribed by NCT?
Yes, my lords, now there I want to show the previous judgment of the Uttarakhand High Court of Justice Joseph, as he then was, page number 148 at page 150. This
Forget about those judgment.
My lords, no.
We are not bound by the judgment of the High Court.
My lords are not. I'm only persuading. This is Justice Joseph's judgment as he then was.
Does that make it a difference?
No, it does not.
Justice Government judgment as a High Court judge, or Justice Mishra's judgment as a High Court judge after judgment of the High Court.
I'm only
they are not binding on this court.
My lords, I'm only submitting it as a persuasion to my lords.
Don't go on repeating.
I would not do that. I'm sorry if I took it that way, but just see for the purpose of
the judgment of High Court of Uttarakhand.
My lords, but this issue came up and the state has accepted it. Now, if the state has accepted it and is binding on the state can't take a different position today. That's all that I'm imploring my lords to take a look at it. And the SLP was dismissed against this order.
That doesn't amount to
but for the purpose of persuasion.
Punay Ahmed.
My lords, I understand. Punay Ahmed. But would my lords look at it in the
सबसे बढ़िया बोल
principle?
दिया।
Because the state accepted
मेरी
this
तरफ
point.
से।
It's binding on the state to that extent. I say
What
that.
was the issue there?
Yes. My lords, here what had happened was, in this particular case, there were students who were again seeking an equality. Now, here the judge court noticed of a higher qualification. My lords, just give me a minute. Yes. My lords, may just take page 150, please. Just forgetting that. Yeah, huh? Yeah. Of the state SLP, my lords. Yes, my lords, it starts at 149. And this was again in the RTE. Now here, the petitioners possessed 2-year diploma course. Please see 148. This was the fact. And they had this diploma course from outside the state of Uttarakhand. So state of Uttarakhand said, my regulations...
So they had 2 years.
My lords, but state of Uttarakhand took a position that my regulations don't recognize...
We are asking about the requirement that their advertisement specifically states that the diploma minimum of 2 years.
My lords, that is why when I started my argument, I showed my lords the letter of state of Uttarakhand. Uttarakhand non-suited us only on the ground that we had a diploma course from NIOS. It says we don't recognize NIOS. They don't say 2 years.
If you wanted to say something.
My lord, I gave the basic qualification and the 6 months course also I completed, the bridge course which was there within 2 years. Still I have not been considered because the 48 bench Justice Dhulia, I have passed an order in Divesh Sharma versus Union of India that it is being applied retrospectively. I request the Lord to clarify the same.
No, what has Mr. Dhulia held?
In the Divesh Sharma versus...
This is B.Ed. This is B.Ed candidates who are wanting appointment to...
Also, I have...
That is not an issue before us, ma'am.
The clarification of Justice Dhulia's
Not say, well, you have to go with
Justice Dhulia. Why you want clarification of that?
I got only 1 minute, Lord. Lordship, time bound activity or quality education under RTI Act.
How can the matter is over now, Mr.
Lordship only seeking consider my candidature government primary school, Lordship. I am a private school non-aided teacher.
Just 1 point.
This will be endless.
No, and not on merits, brother. We, of course, learn from what falls from the court also. Your lordships have seen the judgment passed by Uttarakhand High Court, Patna High Court, and Tripura High Court. In all these 3 courts, the issue that your lordships today that has been raised during deliberations was not considered. Without prejudice, to what we've argued, your lordships will certainly think over it. Please consider, that if at all your lordships take the view that that goes against us, may consider remanding it back also, because I understand that your lordships have heard it, for some time, but today, we are at a situation where the High Courts have not even considered this aspect of what was the purpose of this particular meeting.
That's all. Vacancies, my lord. We are short of teachers. All this.
We live to fight another day, I just want to answer.
Thank you. Extremely grateful to you, Lord. I'm sorry, not the author given a lot of convenience compilation. Extremely sorry. Extremely. My apologies.
The convenience that even when it's not good,
कंपैरिजन आपको नोटिफिकेशन में ऑर्डर
Submissions, my lord, I don't think written submissions I've already handed over. I'm grateful. Extremely grateful. Thanks,
Right, Manoj.
Yes,